Let's talk about force majeure clauses. So remember, this is part of our series on constructive production savings clauses, which are things that under a lease can substitute for production. So if you don't literally have production, you may be able to keep the lease if one of these clauses is activated. So these are circumstances the lease defines as production. That includes shut-in royalties, we've talked about those, a dry hole operations or cessation of production clause, we've talked about those. It also includes pooling and unitization, but right now we'll talk about force majeure clauses. So the force majeure clause, it's typically when there's some circumstance outside of the party's control that prevents the party from complying under the lease. And we'll see that it actually grew out of sort of old common law decisions like those around frustration of purpose that you may remember from your contracts class. So the key questions that we have to ask under the force majeure clause are, what kind of circumstances would allow the company to not perform? If the company is not going to perform because there's some kind of unexpected circumstance that arises, is notice required to the lessor or landowner? And then what kind of performance is excused? Does that mean you just get to keep the lease even though you don't have production? Does that toll the ending of the primary term? That's another one of the key questions about force majeure. Finally, what remedy does the clause provide? Does it give you more time? Does it just mean you can keep the lease? Does it allow you to get out of the lease entirely? Why would you want that? So to talk about that, let's talk about this Perlman versus Pioneer case, which is from the Fifth Circuit, 1990. And this is kind of an interesting case. You have more than 100,000 acres of land that is leased to Perlman to do his patented Perlman process. And that was to produce gas from coal bed methane. And if you look, in the early, a couple decades ago now, there was a kind of a boom in coal bed methane production, particularly in Wyoming, et cetera. And what that was there's gas that sits on the surface of coal that's deposited in the ground. And so there's always been gas on that surface. And in the past, that was often a big danger in coal mines because it was gas sitting on the surface. And so while you were mining, that gas would build up. And if your ventilation wasn't sufficient, there was a spark, you could have an explosion. So there's all sorts of old folk songs about coal mining explosions and all the miners who died in those circumstances. It can be very, very dangerous. But nowadays, when the natural gas is often worth more than the coal because it burns more cleanly, sometimes there's an effort to leave the coal in place but extract the natural gas. And so this Perlman process was about removing water from that surrounded that coal, and that allowed the natural gas to flow up the well and produce it. So that was the patented Perlman process that he was asking for. Now, this was a huge lease, obviously covering over 100,000 acres, both Montana and Wyoming. What happened in the case? How did force majeure get involved? The force majeure clause in this lease said the lease shall not be terminated, nor the lessee held liable in damage if compliance is prevented or hindered by an inability to obtain governmental permits or approvals. Okay, so doing our analysis on this force majeure clause, we can say, okay, look, it specifically notes one of the things that might be something that happens that you worry about is a lack of governmental permits. And if that sort of unexpectedly comes in and stops performance, that's going to excuse compliance. And note that in terms of the remedy provided, two things. One is the lease shall not be terminated, and the lessee, the oil company, Perlman, will not be held liable in damage. And that's really important, as we'll see. So the force majeure clause also says that the lessee, the oil and gas company, Perlman, shall notify the lessor, the landowner, in writing within 15 days of any force majeure event, and shall use reasonable efforts to remove that force majeure. Okay, so what happened in this case? Well, basically, Perlman is trying to get approval for his first wells on the lease using the Perlman process, and he, in Wyoming. And he runs into difficulty from the regulators. And he concludes, those Wyoming regulators, they're never going to allow me a permit to use my Perlman process, and therefore I just want out of this lease. Okay, now think about that. That's a little bit weird, right? Often force majeure is used to say, give me longer to drill. But here, Perlman says, I want out of this lease entirely. Why is that? Well, the reason is because this was an unusual lease. If you look in the facts of the case, starting on page 296, you see that under this lease, Perlman was obliged to spend $1.5 million on this lease. And if he didn't spend it, he had to turn that over to the lessor landowner. Okay, so that is a little bit unusual. Why would you have that kind of provision in a lease? The basic reason is, remember, as the lessor, the landowner, you really want the oil and gas company to drill for oil and gas on your land, because that's the way you'll get royalties, your share of production, and that's where you get most of your money. So you want an incentive for them to act. Now, the normal incentive, there's normally two incentives. One is the oil and gas company gets to keep most of the oil and gas that's produced, but there's another incentive, which is that they paid a bonus. So if they paid a bonus, they're probably pretty serious about drilling. But if you want to be even more sure that they're going to drill, you can actually make a requirement that they spend a certain amount of money. This is actually very commonly used by countries that when they lease their oil and gas prospects to oil and gas companies, they have a dollar spend requirement. And that's great for a country because it tells them, one, you're serious about this, you're going to try and develop the oil and gas, and so I'll get my share. And two, for a country, they may just want the spending, it'll boost jobs, boost the industry, etc. So it's less common in private leases, but we see it here. Okay, so court doesn't buy this use of force majeure. It says there's no hindrance, and Perlman failed to make a reasonable effort to remove the force majeure condition. So remember, the lease requires reasonable efforts to remove force majeure. What's the problem with what he did? Well, one thing he did is he only talked to the Wyoming regulators. He never went and talked to the Montana regulators, and the lease covered land in both states. The other thing is he didn't follow through to conclusion with the Wyoming regulators. They never completely denied him the ability to drill. They had some questions. Maybe he got a read from them that they weren't going to, but he certainly didn't make reasonable efforts to remove that condition. All right, so when we interpret these force majeure clauses, the way courts have interpreted them has evolved over time. So again, the old view was that this is basically like frustration of purpose. When there was an assumption underlying the contract and that assumption has been invalidated that both parties had, well, that might excuse you from the contract. But under that theory, even the events that are listed as force majeure in the force majeure clause of a lease would have to be beyond the control and contemplation of the parties at the time of contract. So even if your lease said failure to get a government permit is force majeure, if the oil and gas company should have been aware that that was a big risk it was facing and that it had some control over whether that permit was granted, then even though it's listed in the lease as excusing compliance, it doesn't really. So that's still the view in California. But in most places, including Texas, it's a contract clause. So we look at what the lease defines as force majeure. We look at the text of the lease. And where this can get complicated is government enforcement. So government enforcement, particularly if the oil and gas company did something wrong. Because if the government comes in and stops the well, well, your lease might say, failure to get permission from the government is an event of force majeure. But what if it's really all the oil and gas company's fault? It was violating its allowables, it did something it wasn't supposed to do, etc. So you can't necessarily rely on force majeure, even if government action would technically be force majeure. If you're doing something wrong that nobody, people would have assumed you weren't doing, right? So there still seems to be a little bit of a leftover of this view from California that, if it's really the oil and gas company's fault, you may not be able to rely on force majeure. But in general, in most states, including Texas, if it's an event in the lease, you're going to be able to rely on it. I should say that another big issue nowadays is what are really extreme market events, right? So it's always been the case that there's just, if you said, well, there's just no equipment available, right? That is often force majeure. So you'd say, there's literally not a rig available to drill. And so that should be force majeure because of some truly exceptional market scenario. Problem is, do we really believe that? What if you say, well, if you paid enough, if you offered twice what everybody else was offering, then probably somebody would break their other contract and come and drill for you. So there's somewhat of a gray line about those kind of market events, about whether they really count as force majeure. Similarly, there's been a big issue nowadays because, as we talked about before, we've had extraordinarily low oil and gas prices. It has been very rare in the past, almost never, to have negative natural gas prices, and now to have negative oil prices, as we did earlier this year, is completely unprecedented, at least in terms of the usual crude oil benchmarks. So in those contexts, is that force majeure? Is that a event outside of contemplation of the parties? Is it included in the force majeure clauses? Of course, that will depend on the force majeure clause in every individual lease. And in fact, there'll probably be a lot of litigation about that if we keep having these negative price swings, and it'll be interesting to see how that plays out. Probably a lot of money on the line, a lot of lawsuits, etc. Okay, so let me read you a sample force majeure clause. Should the lessee be prevented from complying with any express or implied covenant of the lease by reason of scarcity of or inability to obtain or to use equipment or material, or by operation of force majeure, or because of any federal or state law or any order, rule, or regulation of a governmental authority, then while so prevented, lessee's obligations to comply with such covenant shall be suspended, and lessee shall not be liable in damages for failure to comply therewith. And this lease shall be extended while and so long as lessee is prevented by any such cause from conducting drilling or reworking operations on or from producing oil or gas or other hydrocarbons from the leased premises. Okay, it's a very broad clause. I want you to notice several things about it. One is it incorporates by reference the traditional doctrine of force majeure. So it just says, look, or any kind of other force majeure prevents us from acting. It specifically says if there's scarcity or inability to obtain or use equipment or material. So we can't find a drilling rig. So that's going to raise the question, well, is it really unavailable? They try to address it by saying, well, even scarcity could be force majeure. But that could create an interpretive issue about how scarce does it really have to be before this is a force majeure event. Similarly, look, it says any government authority, rule, or regulation. Okay, so that might apply to any denied permit, especially something not expected. But what if it is expected? What if anybody should have seen this rule or regulation coming down? Or what if it's actually the oil and gas company's fault? They did something wrong, and so they were ordered to stop production. So there can be some difficult gray areas, even in a place where we say, well, look, as long as it's within the text, it's still there can be a lot of litigation about these force majeure clauses.